Hi, everyone. Welcome to our training this afternoon. Thank you all for being here. My name is Iris Wen. My pronouns are she, her, hers, and I am the FRC training coordinator. This afternoon, we're happy to have Maria Uriarte and Mari Cruz Montaleno from Disability Rights California to talk about an overview of the IEP and special ed process. First, we want to just briefly talk about what the FRC does here in San Mateo County if you're new here. The FRC of San Mateo serves families who have children with disabilities between the ages 0 to 22. We are staffed by parents and caregivers of children and young adults with disabilities, and we provide support, information, resources, and referrals to navigate the systems. We also offer trainings, support groups, a resource binder, as well as a monthly e-newsletter. I want to give a disclaimer that the FRC is not a legal firm or legal services agency, and we cannot provide any legal advice. Any information provided by the FRC should not be considered a means of taking the place of legal advice that must be obtained through an attorney. With that, we invite you all to connect with us, and our contact information is in the chat. Next, I want to go over some general housekeeping items so that our training runs smoothly this afternoon. We will be recording this training for any families and providers who are not able to attend, so we ask for your collaboration with the following guidelines. Please mute yourself when not speaking to avoid background noise. You can have your video on or off based on your comfort level, and we invite your respect throughout this training. We are offering simultaneous interpretation in Spanish today. So if you haven't already, please select the language that you would like to listen to this presentation in the settings bar under the globe icon or interpretation, and select either English or Spanish. And the instructions are also in the chat. We are offering live automated captions today. So if you'd like to view the captions, you can go to your Zoom settings bar, find the CC icon, and click that to show captions. We will have a Q&A portion at the end of the training. Please save your questions for the end. We encourage you to take notes and write down your questions as they come up so you don't forget them. And during Q&A, you can use the chat box or raise hand feature for questions and comments. During Q&A, we encourage you to refrain from sharing names or any detailed information to protect your privacy and other families' privacies. And after you ask a question, please be mindful of making some pauses to allow our interpreters enough time to translate both question and answer. At the end of the training, we have a survey both in English and Spanish to collect your feedback on how this training went. And DRC will also send out a survey via email tomorrow. These surveys are anonymous and they help us understand how to improve our trainings for you all. And last, we will be sending a follow-up email tomorrow with the materials from this training. Okay, that's it for me, and I'll turn it over to DRC. Thank you.
Thank you, Iris, and welcome everyone. Good afternoon. I hope you're having a great day. I want to introduce our presenter today. We have Senior Advocate Mari Cruz Magdaleno, and we have our Senior Attorney Maria Uriarte. But before we get started, for those who don't know about us, we were formerly known as Protection and Advocacy. We are a nonprofit organization founded in 1978. We provide legal services for people with disabilities. Some of those issues that we work on can be anything from special education, public benefits, regional center services, housing, employment, and we also serve clients who are seeking services from the Department of Rehabilitation, our CAP unit, and we also have a unit called the Office of Clients' Rights Advocacy, and you may have heard of them in your area. They also are one of our sister organizations that provides assistance to consumers or clients or family members of the regional center. I just wanted to also let you know about the different offices we have. Our main hub is in Sacramento. We have an office in Los Angeles, Bay Area, San Diego. And then, of course, our smaller offices are in Fresno, Ontario, and Modesto. All of the materials and links that you see tonight will be sent to your host, and she, in turn, will turn that over to you. So have a wonderful training, and we will talk to you later about Q&A. Thank you. And I'll turn it over to our team.
Thank you, Lonnie. So the good thing today is that we're going to have side-by-side PowerPoints in both languages. So today, next slide, please. We're talking about special education. We're going to talk about the child fine mandate, what is a 504 plan, special ed eligibility, a brief overview of the laws that govern special education. We're going to talk about the education process. And then we're going to talk about what you can do when you're not happy with what's going on. Specifically, we're going to talk about compliance complaints and due process. Due process is really going to a hearing. So next slide. What is the child fine mandate? It's a federal requirement that says that schools must identify all children who they know have disabilities or suspect they have disabilities, and to make sure that they're not in need of special education services. So how does that happen? It happens through assessments. And this child fine mandate covers a child from birth to age 20 through age 21. And it doesn't matter where the child lives, the child or what school the child is going to. It could be private school, public school. It could be a child that moves around a lot, migrant children, homeless children, children who are in foster care. So it's an affirmative obligation that schools in California have to identify, assess, and provide special education services to those children who meet the requirements for special education. Next slide. So there are two sets of laws that govern special education. The first one is a federal law. It's called the Individuals with Disabilities Education Act. I've heard it said IDEA or IDEA, depends on who you're talking to. And then we have state law. Federal law will always preempt state law. So the California education laws cannot do anything different than what federal law is doing. It could add to federal law, but it can't do anything different. So if federal law says one thing and on the same topic, California decides to do something else, that's not gonna happen because federal law is supreme. So when we're talking about federal law, we're talking about IDEA. And you see these are called citations right underneath both acts. So it's Title 20 of the United States Code. That's federal law. Statutes, codes, they're synonymous words. Starting in section 1400. And when you see at SEC, it means and moving forward, right? Past section 1400. So statutes or codes, remember they're synonymous, come with regulations, and the regulations implement the law. So when we're talking about regulations, the federal regulations start in Title 34, Code of Federal Regulations starting in Part 300. California special education's laws start, it's the Education Code starting at Section 56,000. The regulations that implement the law are found in Title 5, California Code of Regulations, Section 3000 et sec. It's really important, you know, as a parent, you're going to be involved with the district for at most perhaps 21 years, in some cases maybe 18 years, who knows. So it's really important that you know the law, because if you know the law, you know your rights. You know when someone's saying to you something that you know is not correct, and you might be thinking to yourself, well, you know, this is a bit too much because there's so much to know, and that's true. But what we do is we have a manual on our website called the Special Education Rights and Responsibilities Manual. and it has a lot of information on the law, and it's in question and answer format. And the answer will include the law that addresses the answer. So you'll be able to know where to find the law because the answer will have the law. It might cite to a federal statute or federal regulation or a California statute for the same proposition. So yes, there's a lot to know, but you can start to know by reviewing materials like the manual. We have other publications online. Join these kinds of trainings where you can learn a lot, talk to other people who can probably, give you information you didn't know before. And it's important that you know the law, not only so that, no one pulls the wool over your eyes, but also when you're wanting to file a compliance complaint, that you're going to need to know what law or why you think that the school district violated the law. And we'll talk more about that later. Next slide. So the federal law under IDEA, there are a number of entitlements. So kids in special education are entitled to a free and appropriate public education. Placement, the first line of thinking should be the least restrictive environment. We're going to talk about all of this. They're entitled to assessments. They're entitled to an individualized education plan, which is the contract between the parent/student and the district. They have rights to file complaints and to go to a hearing. And before the hearing, we have other steps that are available like mediation and formal conference. Next slide. So what is free and appropriate public education? It's specialized academic instruction plus related services that are at public expense. So the school district cannot charge the parents of a child in special ed for the services and supports that the child is getting. Of course, the school needs to meet the standards of the state educational agency. And it is this FAPE idea is also available through high school, and it's provided in conformity with the IEP. So what is the least restrictive environment? So when the district and the parent are talking about placement, what kind of class is my child going to be placed in? General education, maybe general education with pull out, special day class, non-public school. Like, what is the placement? The thinking or the first consideration should be the least restrictive environment, and that is the general education setting. And if the child needs services and supports within the general education setting, or maybe some pull out to go and out of the general education setting during the day, that's really where the conversation should begin. If parents are not sure about what's the appropriate placement for my child, you can ask the school to do an assessment. These assessments are for placement. They're done by what are called inclusion specialists. And that person will do an assessment of placement. If you're not happy with the assessment, you can always ask the school for an independent educational evaluation. We call it an IEE. And Mighty Cruz is going to talk more about IEEs. Next slide. So what is special ed? It's not a place that you go to. It's a pool of services so that the child can receive a free and appropriate public education. Next slide. So there are disabilities that can qualify a child for special education, and they are listed right here. So, for example, autism, or maybe a child with other health impairment or a hearing impairment or multiple disabilities who, by reason of the disabilities, need special education and related services. But it's not enough to have a disability. There's got to be more. And we're going to go to the next slide for that. What is that more? Well, the age. It has to be for a student between the age of 3 up to the end of 21. And there's an assessment that's done to evaluate whether the child needs special education services. And that assessment has to show that the student's disability adversely impacts the student's educational performance, and therefore the child needs special education. So this is the magic language. Not only do you have to have the disability, but the assessment has for special education has to show that the disability adversely impacts the child's ability to learn, and therefore the child needs special education services and supports. In our special education rights and responsibilities manual in chapter 2, there's more information on evaluations and assessments. And that's the link to that chapter. Next slide. So we just visited the federal and state laws applicable for special education that involves special education. There are other federal laws that apply to school districts, and the first law that applies to school districts is Section 504 of the Rehabilitation Act. And the second one is Title II of the Americans with Disabilities Act. So Section 504 came first, and then Title II came second, but both laws apply, and they are anti-discrimination laws, meaning that, for example, any entity receiving federal funding is subject to Section 504 of the Rehabilitation Act. And it prevents these entities from discriminating based on disability. How do you discriminate a child based on disability? Denying a reasonable accommodation, we're going to talk about that, or maybe outright discrimination. Let's say that I have a child who uses a wheelchair and he's told that he can't go on a field trip. They're going to go out to the mountains because he uses a wheelchair. That's outright discrimination. Districts, we know, receive federal funds, and so they are subject to Section 504 of the Rehabilitation Act. Title II doesn't require that entities receive federal funding. It just is another anti-discrimination statute that applies to schools. Next slide. So sometimes you'll hear, that, oh, that child has a 504 plan. So there are children with disabilities whose disabilities do not adversely affect their educational performance. Remember, to be eligible for special ed, the disabilities have to adversely affect their educational performance. But there are students with disabilities where that's not the case, but yet they need accommodations to be able to access and benefit from the school's programs. So, as I said before, Section 504 prohibits discrimination. And it's not only for students who have disabilities, it's also for students who have a record of such an impairment or are regarded as having such an impairment. So, for example, a child who has had cancer, no longer has it, it's in remission, could be someone who's regarded as having such an impairment or have a record of such an impairment. But also the student has to have a physical or mental disability which substantially limits a major life activity like learning, depression, sleep disorder. So that's the qualifying criteria for 504 to apply to a student. Next slide. So children who are eligible for a 504 have a 504 plan. That's not to say that children who are in special ed can't have a 504 plan. Yes, they can. They can also have reasonable accommodations, and those accommodations would be in the IEP. So students who are in special education are have the protection of IDEA and California state education laws, special education laws. They have greater protections, procedural protections and guarantees than a student who has just a 504 plan. But regardless, it's these anti-discrimination laws are super important because we know that this kind of disability discrimination happens, and there's a remedy for that. Next slide. Okay, so examples of reasonable accommodations. So let's say my child who uses a wheelchair can't really access the desk that in his classroom. So as a reasonable accommodation, as a parent, I could ask the school to provide an accessible desk so that my son can use the desk in the classroom. And just note the words reasonable accommodation. The accommodation that you are asking for has to be reasonable. If there's something that costs less that's going to do the trick, then the school is going to say what we're suggesting, that something that costs less that will do the same thing. Then you parent are asking what we're saying, what we're suggesting is reasonable. What you're suggesting is not reasonable because there's something else that can fit the bill, so to speak, at a lesser cost. Other types of reasonable accommodations, the child may need to be seated in the classroom maybe in the back of the class or in the front of the class. The child may need to have the lessons recorded. The child may need, as a reasonable accommodation, to have the homework modified. So for example, rather than doing 20 questions of math for homework, the child only has to do 10. In the area of testing, maybe the child needs a quiet space or needs extra time or needs to have breaks, while testing. Maybe every 45 minutes, the child may need a 10-minute break, whatever the reasonable accommodation is. And of course, there are many, many, many different types of accommodations. I know that if you Google reasonable accommodations for, let's say, learning disability, there's a lot of resources. There are a lot of resources on the internet for parents to get ideas of the types of accommodations that are available. And there are people at school who can help with that too, to identify what the reasonable accommodations are for the student. Next slide. Okay, now I'm going to hand this over to Mari Cruz, who's going to talk about the special education process.
Great, thank you, Maria. I am gonna keep my camera off just for accessibility in my end. So Maria just talked about the eligibility criteria for special education, then the laws and regulations pertaining to special education. Now we're gonna see how the actual process would look in and what are you looking at in regards to timelines when starting the process? So a referral for special education services is required to initiate it. And that referral could come by a parent or a school staff who might have any kind of suspicious of disability. So a parent does not have to wait for the school to identify the child to have a disability. If parents have any concerns about a potential disability, they can certainly bring it up to the school's attention and initiate, and that would initiate the process. So, and the first step into the process is the referral. Then after the referral is done, the school has 15 days to develop an assessment plan and present it to the parent for signature. So parent signature is required in order for the school district to initiate the assessment process. So if the school is not able to obtain that signature, the process doesn't necessarily get started until the signature is obtained. The school should assess in all areas of suspected disability. And again, that could be indicated by school staff or parent. After the assessment plan is signed, the school district has 16 days to complete the assessment and to meet with the family, with the parents, and review the reports, from the assessment. After the assessments are reviewed, the school district has to develop an IEP, Individual Education Plan. So the implementation of the plan does not happen until parent signs that IEP. So we're going to talk a little bit more about signature in our next slides, but just know that after the IEP is fully developed, there has to be a signature from the school and a signature from parent agreeing to the document. And if the school is not able to obtain the signature, they cannot implement the plan. The plan should be reviewed or at least every year. And parent can request an IEP meeting as needed. So when the parent requests an IEP meeting, the school district has 30 days to convene that meeting. Also, the school has an obligation to conduct re-evaluations at least every 3 years, unless otherwise parent or school has any concerns and request new or additional evaluations in between that 3-year period. Next. And so here we just have a blank assessment plan. So it shows whether the assessment is initial, it's an annual, a triennial, a transition, an interim, or other. So the initial assessment would be when the parent or the school have requested the child to be initially requested for the child to be assessed for special education. Then there is an annual, then there's a triennial. So whichever one it's marked in this form is the one that the school district is going to be conducting. And it has all the demographic and general information for the child to be assessed. Next. Okay, this is the actual assessment plan that will indicate the areas that the school district will be assessing. And it could be academic achievement, it could be health, it could be concerns for intellectual disability, it could be language and speech, motor development, social emotional, adaptive behavior, post-secondary transition, and others. Again, this list is not exhaustive, so if there's anything that it's not in the list, the school district can still hold an assessment. It just needs to be identified on what exactly it is that they're going to be assessing. There is a box there for parents to consent to the assessment. There's also a box that says, I do not consent to the proposed assessment. And there is a box to add additional assessments, like if parent would like the school to assess in any other area that it's not marked here in the assessment plan. And just to mention, one, if parent has concerns regarding behaviors and there's not a behavioral assessment listed on that list, you can ask for that specific assessment to be added to it. The plan will also say who will be conducting the assessment. Next page, please. So the assessments are quite important. The assessment is actually going to help to identify the student's needs in all the different areas. And here we have a list of some of the areas that could be assessed, such as occupational therapy, physical therapy, speech therapy, functional behavior, assistive technology, social, emotional, and behavioral needs, educational related mental health services, support, and more. Again, parents could help to identify the areas in which the student might need assistance and could bring those up to the attention of the school as necessary. Next page. Okay, so I mentioned that the school has an obligation to conduct, to re-evaluate and conduct assessments at least every 3 years. So after the school conducts their own assessments, if the school, if the parent does not agree with the outcome of those assessments, the parent has the right to an independent educational evaluation at public expense. And what that means is that after getting the assessments from the school, parent doesn't agree with it, they have the right to request basically a second opinion, where you would be asking the school district to pay for an outside assessor to conduct the same evaluation so that you get a second opinion, because for whatever the reason is, you're not agreeing with the result from the assessment conducted internally by the school. So once you make a request for this kind of assessment, the school district does have 2 options. The first would be to pay for the independent evaluation, and the second would be to file for due process and prove that its own assessment was appropriate. Typically, when parents request an independent evaluation, what I see most is that the school agrees to pay for the independent evaluation rather than filing for the process right away. And part of that reason is because it's so much cheaper for the school really to pay for an independent evaluation than to fund a due process hearing. One of the things that I do want to highlight here is that you cannot ask for an independent evaluation or outside assessment unless the school district have had the opportunity to conduct their own assessments first. Because I work with parents where they have a relationship where they really don't trust the school and don't want the school to assess their child. And the reality is that the school has the right to assess them first. And after that, if you don't agree with it, you can go ahead and ask for the independent evaluation, but you cannot ask for an independent evaluation if you have not given the school the opportunity to conduct their own assessments first. And here we have a link to a sample letter to request an independent evaluation, and it is part of our it's part of our special education rights and responsibility manual. Next page. In regards to the school giving you notice for the IEP, the school district has to provide you with written notice of an IEP meeting, and the meeting should be scheduled on mutually agreed date and time. The school cannot hold a meeting without first giving you the opportunity to participate, to invite you and to participate in the meeting. I do want to say that if the school district has invited you to a meeting and you are simply not responding, and they have multiple attempts to reach out to you and to invite you to the meeting, and again, you're simply not responding, the school district might go ahead and hold a meeting without your participation and argue that you refuse to participate in the meeting. You do have the right to request an interpreter. If English is not your primary language, you do have to do that in advance so that the school could be prepared to have that interpreter available for the meeting. You have the right to audio record the IEP meeting as long as you provide the school district with a 24-hour notice. I want to mention that I know that nowadays we have easy access to technology, but unfortunately, if we do not notify the school about the recording of a meeting and you just go ahead and record without notifying the school, that recording cannot be used in any legal proceedings. If the school was not notified about the actual recording taking place, that recording cannot be used. Go ahead, next. So once the contract is finalized, the IEP becomes a legal contract between the school and the student. So once both parties sign the document, it becomes legal. The IEP must be held annually, and after an assessment is completed. And again, parent does have the right to request additional meetings if necessary, because the IEP document, it's not set in stone, simply because we are humans and we're always changing, and especially kids, they're growing, their abilities and skills change rapidly, and also challenges might come up. And so if that happened in between the annual process for the IEP, parent can always request a meeting. And once parents request that meeting, it must be convened within 30 days. We do recommend that you do the request in writing so that you have a record that you actually requested that meeting. I've seen parents request emergency meetings. There is no timeline in regulation for emergency meetings, but that typically happens when there is something that involves health and safety. And the school does tend to respond a lot quicker when there is some of those concerns. But again, there's nothing in regulation that sets timelines for emergency meetings. So the purpose of the IEP meeting is to meet with the parents to discuss all of the relevant information. In preparing for the meeting, it is recommended for the child to be included to the extent that it's possible. For little ones, you know, they might not really be able to participate in the meeting, so they might not really know the process and not be able to have a whole lot of participation. So it is, it would be understandable, but we do have young, like kids who are getting transition age, and it would be important to include them in the IEP meeting so that they have participation about their future plans and their goals and what they would like to work on while they're in school. We do recommend that you make a list of what you and your child would like to happen for the school year. You might want to write down notes about goals, needs, and concerns that you have. And I know that we might think like, well, I know what I want or what my child needs, but the truth is that it's quite intimidating to be sitting around a table full of people, and you might forget things. And you might not be able to direct the meeting in the direction that you're thinking of doing it. And that's where notes and having a list of the things that you want to address during the meeting are very helpful. You might want to bring support to the meeting, and that could be a family member, it could be a friend, it could be someone that has experience in this process. You can bring an advocate. You have the right to invite whomever you want to participate in that meeting or to support you. Again, provide the school with a 24-hour notice if you intend to record the meeting. Provide written requests for accommodations or an interpreter. We cannot assume that the school district is going to be able to come up with an interpreter or to provide accommodations if we have not notified them in advance about that. We also recommend that you review the last year's IEP, if there is one, so that you are familiar with where was your child at the year before and the goals that you're going to be planning for the next school year. Also review any assessments. If you do not have the assessments, you do have the right to request a copy from the school. And in fact, if there are new assessments, we do recommend that you request a copy of those assessments ahead of time, because the reality is that assessment reports are quite complex, and you might not have the ability to read and understand those assessments at the same time that everyone is talking about them, and that they're trying to work with all the findings to come up with a plan. And in order for you to have a productive meeting, it would be recommended that you are that you would at least know what those assessments say, so that you have, again, a meaningful participation. Review any materials you have received throughout the year before the meeting, and including disciplinary records, report cards, and progress reports, and students' work. That would really help to to draft appropriate goals and objectives for your child, and to address any concerns. Behavioral needs, it's one of the typical ones. If there are any disciplinary records you want to know about, you want to have those available, so that if additional services and supports are necessary, you can discuss that during the IEP. Next page. So the IEP team or the school is required to have a specific people attend the IEP meetings, and they are required to be there and to participate in the meeting, and that is the parents, the student when appropriate, the special education teacher, a general education teacher, a school district representative, service providers, person who conducted assessments, and a parent, friend, or advocate when it's requested by parent. So like I mentioned, these individuals are required to participate in the meeting. And if there's any service provider or any of these individuals that are not able to participate in the meeting, the school must require a signature from you, parent, to continue with the meeting without the presence of any of these individuals. So let's say that your child is receiving occupational therapy, but the occupational therapist is not available to participate in the meeting. Well, you would have to excuse that person from being present in the meeting. If you do not excuse that person from the meeting, the school district will have to reschedule the meeting if their required members are not available to participate. Next page. So the IEP does require a specific things to be included in the IEP. And so starting with the eligibility of the student for special education services, that's typically listed on the first page. The IEP document should also include present levels of performance, like how is your child doing right now in the different areas that they are looking at. It should have goals and objectives for the school year. It should have related services, and related services are basically all of the services that your child will need, and such as occupational therapy, speech and language, physical therapy, all of those are called related services. Accommodations and modifications, behavioral plans, that if your child is someone who's having behavioral challenges, there should be a behavior plan that should be a part of the IEP. An individual transition plan, if age appropriate. So for those students who are 16 and over, they should have a transition plan. And again, that's additional document that would become part of the IEP. Classroom placement, where is your child going to be attending school? Team notes, computerized system or handwritten. So the IEP notes are quite important. It should be a clear reflection of what happened during the meeting, all of the discussions that went on throughout the meeting, because in the final document, just to mention something, it would talk about goals and objectives, but there is a lot that happened in setting up those goals and those objectives. You know, there might be differences between parent and the school district, and even though at the end the goal is that parent and school will reach an agreement, but the notes should reflect the discussions that took place during the meeting and how the school and parent came to an agreement about things. And that's important, because if you ever have any disputes with the school and you have to end up at a due process, those notes should shed some light about what happened and what are the disagreements, and whether the school and parent, you know, have concerns about a specific services, or if anybody, notice additional needs and the school either not respond to them or not respond to them properly. So it is important to document everything in the IEP notes. If you go through the IEP meeting notes and you find that there are things missing from the notes, you can ask the district to include your own notes. Like you as a parent, you can, as you go through the meeting, you can come up with your own notes. And again, you can ask the school district to add them to the IEP meeting. If the district says no, we cannot do that, we will not do it, you can file a compliance complaint. What happened with a lot of the parents that I work with is they review the IEP notes from the school, and they have if there are things that are missing or not accurate, they bring it up to the school as a point of conversation to say, okay, this happened during the meeting and we just noticed that it's not included in the notes. Either can you add it? If the school district is willing to modify the notes or to amend the notes, that's great. But if they are not able to come to an agreement with the school, then adding parents' notes to the IEP, it's recommended. And again, if the school district does not allow you to do that, you can file a compliance complaint. And we're going to talk a little bit more about that process in the next slide. So now let's talk about what are parents' rights at the IEP. So parents have the right to a meaningful participation in the IEP, asking any and all questions, submitting an agenda or concerns, taking time to think about the IEP. So
just the fact that parent is sitting at the IEP table does not imply that parent is having a meaningful participation. The school should allow you to provide any input you might have, to ask questions as needed, and to bring up all of your concerns. Parents have the right to an interpreter at the IEP free of charge. And as I mentioned before, it must be requested in advance. We cannot anticipate that the school is going to be able to have an interpreter available if we have not notified them that we need one. Parent might record the IEP if they give 24-hour notice. Parent consent is required, and an IEP cannot be implemented without consent. This is quite important. I feel in a lot of the conversations I have with parents, parents do feel pressured about signing that document because they say, well, if you don't sign the document, we're not going to provide any services. And that it's not necessarily true. It is true that if there are changes to be added to the IEP, additional services, that they're not going to take place until the actual document is signed, but the school has an obligation to continue implementing the last signed IEP. So the new IEP does not come into effect until the parents sign, but the last signed IEP will still be in place. And it is okay for parents, if they have any concerns, to be able to say, let me take the document home, I will review it and I'll get it back to you within 24 or 48 hours or whatever time they think they need to review that document. They can certainly do that. And they should, parents should not feel pressure to sign the document right there and then if they haven't had an opportunity to review it, or if they feel like there are things that they want to consider or they want to make sure they are noted in the document as they were agreed upon the actual meeting. parent have three choices when consenting to adopt to an IEP. The first one is consent in full, meaning I agree to everything that is written in this document. The second one is dissent in full, like I don't agree with anything that appears in this document. And the third one is consent to some parts of it and dissent to others. When parents are choosing this last option, I do recommend that they spell out the things that they are not agreeing with in the IEP document. So, okay, I am agreeing with placement, and I am agreeing with occupational therapy, but I am not agreeing with speech therapy, and I am not agreeing with I don't know, that my child was denied a one-to-one aid. So, or whatever other services are in discussion during the meeting. So that has to be very explicit to say the things that you are agreeing with and the things that you are not agreeing with. Parent must receive a full final copy of the IEP. Do not leave without it. Again, if you're not ready to sign and you need some time to review it, you can certainly do that, but you need to take the IEP with you home. I've seen it where the school doesn't have the document finalized during the IEP meeting, and they ask for some time to do that. But I've also seen it where they say, oh, can you just, this is, I mean, we agree to everything. We don't have the document finalized, but can you sign the last page to say that you agree with it? I would absolutely say don't do that unless you have the actual document fully drafted and you have had the opportunity to review it. I do not recommend that you sign it. If English is not your preferred language, you might request a copy of the IEP in your primary language. That's not going to be available for you right there and then. The school does have time, and Maria, let me ask, is there a set time for
No, it says reasonable time. So in my mind, what's a reasonable time to get? I don't know, Maricruz, what do you think is a reasonable time from the day of the IEP for the parent to get a translated copy? What would be reasonable in your mind?
I'm thinking 30 days. I think if it's taking over that, I wouldn't consider it reasonable. And again, it's because parents do have the right to review that document. And typically what happens is that the school have someone or the interpreter review the drafted IEP with you. You can also, as I mentioned at the beginning, you can take it home and have someone that you trust go over the document with you, and then if you feel comfortable, you can go ahead and sign it. But definitely, if you feel like that you have reasonable reasons to, not trust the school, I wouldn't recommend you signing it. And you can definitely let the school know, like I am ready to sign the IEP, but I just want to make sure I have the translated copy available just to confirm that everything is as we discussed during the meeting, and that's totally okay. And I think that even puts a little bit more pressure on the school to get the document translated faster than normal. I've heard some cases where the IEP is taking 3-4 months to be translated. I wouldn't consider that reasonable.
Neither would I.
Yeah.
No way.
Yeah, so you can file a compliance complaint if they are not translating the IEP document within reasonable amount of time.
I on a related topic to an IEP, this is the danger you can get into and you don't think about it because it can affect other public benefits. So I had a client whose mother had requested in-home supported services protective supervision. And for protective supervision, you have to show there's a criteria that a criterion that requires that you show that the person needs supervision 24 hours a day, 7 days a week. So it was denied. And I was talking to the mom and I said, well, what documents did you give the social worker? And she said, well, she asked for the IEP and the IPP. And I said, send them to me. I want to see them. And in the IEP, mom is monolingual Spanish. The IEP was in English, signed by mom. And in the IEP, it said, per mom, child only needs to be supervised while at school. And so I call mom up and I say, well, I know why they denied it, because you have signed a document that says that you said that he only needs to be supervised while at school. And she says, well, I didn't say that. And I say, but why did you sign the IEP? And she said she felt it was in English. They told her she would get one in Spanish eventually. And they were pressuring her to sign the IEP there and then. And I said, well, this is how you're going to describe it when you go to a hearing on the IHSS denial of protective supervision. This is how you're going to describe what happened and why you signed this IEP that you didn't understand, that you trusted that the district had everything in there that had been discussed. So it's just a word of caution. Like Mari Cruz says, don't sign it. If you don't understand it, do not sign it.
Yeah, that's a great example, Maria. And also, I think what you said, it's really important to document everything thoroughly in the IEP, because these documents are usually the documents that are considered for other services such as IHSS, regional center eligibility. These are the documents that are going to go to the other agencies to look at the level of service that your child needs. And if these documents are not true, or they don't have all of the information accurately, it can affect the eligibility for other services. So it is quite important that everything is clearly documented and that you feel comfortable talking about your child's needs. Because I know, and you know, we all want to talk about how great our kids are, and I am sure we all have great kids. But when it comes about the IEP, we have to talk about the challenges too, and that it's okay. The reason the challenges have to come up and they have to be written in these documents is because eventually that is going to translate to services. And if we're only talking about the good things of our children, services are not going to come, unfortunately, because we are talking about all the areas of strength and all of the good things. And that is absolutely great. But again, we need to talk about the challenges, because identifying a child with a disability, so we are not saying that we have bad kids. We're just saying we have kids that need a little extra help in certain areas. And if we are not talking about them, the services are not going to come. So I think it's really, really important. I couldn't stress enough that documentation has to be cleared. It has to be, and it has to include parent input. Because the school might be seeing something that you're not, or you might be seeing things that the school is not, and it all has to be recorded in this document. Next page. So,
Okay, I'm next.
yeah, I will turn it to Maria now. She's gonna talk about complaints.
Yeah, what happens when you not happy with what's happening or not happening or not happening with the district? I want to talk about compliance complaints because they're really, really important. And when do you file a compliance complaint? Is when the district is not following the law, violation of rights, violation of law. So for example, the IEP is a contract, right, with parents, student, and the district. And if the school is not providing a service that it agreed to provide in the IEP, they're violating the law because the law says that they're supposed to. So that would be the subject of a compliance complaint. The child fine mandate. You know, schools have an affirmative obligation to identify children they suspect have a disability, assess them. And I've seen that not happen. And that would be the subject of a compliance complaint. Failure, let's say that the IEP team meeting, they meet, but without the parents. That would be subject of a compliance complaint because the law says that the parents are an integral part of the IEP team. Or what if the parents go to a hearing and they win and there's a decision in their favor, but the school is not implementing that? The school is failing to comply with the decision. So just think about compliance with the law. And for that, you know, you're going to need to know what it is and go to our SIR manual and do all these things, you know, participate in these kinds of trainings. Another example would be if you, within 24 hours, you notified the district that you wanted to record the IEP meeting. And when you get to the IEP meeting and you have it in writing, you sent, you know, an email to the school district. And when you get to the IEP meeting, they say that you can't record it. That would be subject of a compliance complaint. And these compliance complaints, you have to file within 1 year of the date you claim was a violation of special education law, right? Within 1 year. Of course, you're not going to wait 1 year because a lot of time goes by and your child may not be getting you know, what the child needs. So of course you're going to try to file it as soon as possible. But there are always deadlines with these kinds of things. And you're going to file that compliance complaint directly with the California Department of Education. They have 60 days to investigate. And if the investigation shows that the district is out of compliance, they're going to issue a corrective action plan. They're going to ask the district to issue a corrective action plan. I want to distinguish a compliance complaint with going to due process or going to hearing. And I'm going to do it right now so that we have a clear understanding when you file for due process or go to, same thing, go to hearing. When you have issues about placement, you don't agree with the district about placement, eligibility for special education. If the school denies eligibility for special education, that would be a due process hearing. When you request a service and it's denied, when your child has a service and it's being reduced, or when the school takes away the service. Those are the subjects for due process. Violation of rights, compliance complaint. Now, let's say that you feel that the district has discriminated against your child based on disability. Either it was outright discrimination or failure to provide a reasonable accommodation. You would be filing a complaint with the U.S. Department of Education Office of Civil Rights. You have 180 days to do it from the date you allege the discrimination happened. There's no deadline for the investigation to complete. And in our SIR manual in Chapter 6, we have a lot more information about compliance complaints and complaints to the Office of Civil Rights. Next slide. So if it's the subject of a due process, placement, eligibility, service denial, service reduction, service takeaway, they take away the service, your remedy is not a compliance complaint, it's going to a hearing called a due process before the Office of Administrative Hearings. But before you get to a hearing, there are possibilities to try to resolve the matter with the district. And one of those possibilities is a pre-hearing resolution. So if you've requested the hearing, the district has to offer this. If the district files for due process, it doesn't have to offer this pre-hearing resolution meeting. If you're going to have an attorney, the district is allowed to have an attorney at that meeting. If you're not going to have an attorney, the district can't have the attorney there. It's an opportunity for you to sit down with the district and try to figure out if there's a resolution, or also to understand the issues better, right? Both sides will walk away from that meeting, if not with resolution, at least a better understanding of things. What you say in this pre-hearing resolution meeting is not confidential, meaning that at a later event like a mediation or at the hearing, you could bring up information from the pre-hearing resolution. Let's say that at the pre-hearing resolution, you, the parent, agreed to X, and you agreed to X to try to resolve it, but it didn't resolve. You're now at a hearing. What you said, the school district could bring up that you had agreed to X, although at the hearing you're asking for Y, for more than what X would give you. Yeah, the district can bring that up at the hearing, because what you say at this pre-hearing resolution conference, which you would have agreed to, etc., is not confidential. So we say best practice is to sign an agreement where both parties agree that what is being said in this pre-hearing resolution will be kept confidential. If there's an agreement, it's signed by both sides, it's legally binding, enforceable by the court. But like other things, you have, you may have buyer's remorse, as they say, and either side can rescind the agreement or revoke the agreement within 3 days of signing it. And this pre-hearing resolution conference has to occur within 15 days of the district receiving your request for hearing, and it has to be completed within 30 days of that. So it's a very short timeline for that. Next slide. The other thing that could happen is go to mediation. And it's different from a pre-hearing resolution conference, because what is said during the mediation is confidential. It cannot be brought up. Let's say if you go to hearing, there is an administrative law judge from the Office of Administrative Hearings that acts as the mediator. That judge is not there to hear the case and decide on the case. That judge is there to try to bring the parties together so that there's no hearing, so that you come to a resolution. It is not going to be the same judge that hears the matter if you go to a hearing. And so, with the pre-hearing conference and mediation, you might have multiple issues that are going to hearing, and you might be able to resolve some of the issues or all of the issues. Whatever you don't resolve, either in the pre-hearing resolution conference or in the mediation, goes to hearing. So maybe through these two processes, you might be able to resolve, if not everything, some of the things that would have gone to hearing. And so, the mediation, asking for a mediation doesn't change the 45-day timeline to go to hearing, because that's the timeline. So, but sometimes you can extend that if you need to. Asking for a hearing, you have 2 years from the date of the alleged action. Let's say they denied eligibility. 2 years from the day they denied eligibility to file for a hearing. Why in the world would you wait 2 years, right? You would want to file for a hearing as soon as possible. 2 years in the school life of your child is a big deal. And it's heard by, they say, an impartial hearing officer, an administrative law judge. It's not like a formal trial like you see on TV if you go to Superior Court or federal court. It's these hearings take place in a room. The judge is seated at the head of the table. One side is on one side of the table. The other side is on the other side of the table. very informal. And so again, I want to reiterate that Chapter 6 of our SIR manual has information on everything I've just talked about. Next slide. Okay, we're giving you some resources, the California Department of Education, Office of Administrative Hearings, that's the office that will hear your case. And by the way, if you go to the Office of Administrative Hearings website, you can find hearing decisions on special education. And this is the same office that hears regional center cases. And they also have hearing decisions, regional center hearing decisions. So you could actually go there and type in, let's say that you want to see what decisions have been issued regarding compensatory services. You type in the search function compensatory services, and what will pop up is a series of decisions by administrative law judges from the Office of Administrative Hearings. Why are they informative? Because they teach you about the law and they teach you what facts the judge relied on to make his or her decision and what was missing, right? So it's very educational. Next slide. This is our intake line. So if you have any questions about special education, you can go on our website, which is the link is right there to learn about the subjects that we specialize in, regional center, special ed, public benefits, etc. Please visit our website or call our intake line. And we are at the end of the presentation and we can take questions at this time.
Okay, thank you everyone for attending our training this afternoon. We appreciate you spending your afternoon with us. Big thank you to Maria and Mari Cruz and Lonnie from Disability Rights California, as well as our interpreters, Sabrina and Clara. Please take a moment to fill out the survey that's in the chat. And we are also currently planning our trainings and support groups for the upcoming year. So we would love to hear your feedback for our planning purposes, which I'll also put in the chat and send via email tomorrow. Thank you, everyone. Have a good night.
Everyone, good night.
Have a good night.
Thank you, Maria Cruz. Thank you, Lonnie and Maria. Thank you,
Thank you.
everyone.
Thank you. Have a nice evening.
Bye.